Thank you for taking the time to be with us this afternoon for our green card for physicians pending legislation. My name is Angela Lopez. I'm a shareholder and head of the immigration section at here in our firm. With me today is attorney Michelle Alonzo.
Hello, good afternoon. I'm also a shareholder with Cowles Thompson and work in the immigration practice group.
Great. So again, thank you for taking the afternoon and the time. A couple things before we start our presentation. We would like for you guys to be aware that we are muting you during the presentation, so you're not going to be able to speak up. But the great thing about webinars is that you can ask questions during the presentation. If you look at the bottom of your screen, you're going to see a small icon that says chat or messages. You can type your questions there. We will try to answer the questions as you ask them throughout the presentation, but in any event, we will also have time for questions and answers at the end of the presentation. So we welcome and want you to please write your questions, let us know, and we will definitely try to answer the questions either during this presentation or after the presentation via email. So let's start. We have a lot of material to cover, and I know you are anxious to ask your questions. So basically, or what we're doing here today is we're going to talk about the two main bills or legislations that are pending in Congress. The main bills or legislation are the Healthcare Worker Resilience Act and the Health and Economic Recovery Omnibus Emergency Solutions Act, or the HEROES Act. So we will be talking about the Resilience Act and the HEROES Act because the entire name is too long. So for the Resilience Act, and this is the one that it was introducing in the House of Representatives, it was passed, and now was introduced in the Senate on May 5th, 2020. Which means that it's a step ahead of the other bill. And this is the one that we are optimistic. There's a lot of groups and associations and individuals pushing for something to be done in terms of obtaining green cards for physicians, to facilitate the obtaining a green card for physicians. The other bill, and we'll talk about it later on, it was introduced in the House on May 12th. It passed the House. It was approved. However, it has not yet been introduced or presented to the Senate. If you see, the bills have different numbers and letters. So the S is for Senate, and that's the number that the bill has in the Senate, 3599. When it was in the House, the bill was, it was the HR 6788. So if you hear about this HR 6788, you need to know that it's already in the Senate and it has a different number, but it's the same bill they're talking about. So the Healthcare Workforce Resilience Act, or Senate 3599 bill. The purpose of this bill, and it's rather short because it's only to address green card for physicians. The purpose is to recapture 40,000 unused immigrant employment-based visas for professional nurses and physicians, EB employment. So how are they going to do that? Well, for those who are not familiar with the priority date in the system, how it works, in the United States, immigration can only grant so many green cards per year. And per year, we're talking about fiscal year, October 1st to September 30th. And every year on October 1st, we have a new slate. We have new green cards to be granted. And if in the previous year, the Department of Immigration or the Department of State were not able to use all the green card visa slots that were available for that specific year, then those visas are lost. With this bill, what they're trying to do is to recapture, and listen to this one because I couldn't believe when I saw the date. They are trying to recapture the numbers for fiscal years from 1992 to present. And when they were looking at how many visas they were not able to grant throughout all these years, they came out with 40,000 unused green card or visa slots available. So those are the numbers, and that's how they're going to have 40,000 available visas that they were not counting on, and they decided, well, let's go back as far as we can and see how many visas we have available. That's how it is. So because it is for physicians and for nurses, so they are reserving 25,000 of those 40 for nurses and 15,000 of the 40,000 for physicians. What are the requirements? Well, the basic requirements is there's got to be an I-140 petition. For those of you who may not be familiar with what an I-140 is, that's the basic petition for employment-based immigrant petitions. So there's the requirement is that the physician that is going to take or use this or take advantage of this legislation has to have filed an I-140 petition, and the following is this language, the language from the act, before the day that is 90 days after the termination of the president's declaration of the COVID-19 national emergency. Remember, the national emergency was declared on March 13th, and I put there the link, and we'll be emailing you copies of this presentation. So the link to the emergency declaration. So to put this into context, for example, if President Trump comes and says, well, we're going to terminate the national emergency on August 31st, 2020, just to say something, then the I-140, for purposes of this legislation, must to have been filed before November 29, 2020, meaning within 90 days before, okay, the termination of the president declaration. Okay. The next requirement, or the other requirement that is followed, is that if the individual or the physician is to obtain the green card at a U.S. consulate, that means the physician is not filing the I-485 in the United States, or if for whatever reason the I-140 was already filed and he may not be in the United States but already meets the requirements to apply for a green card and is doing it at a U.S. consulate, then when the physician goes to the consulate for the interview, he will have to present a letter from the employer that is offering that employment, a letter that attests that the hiring of the nurse or the doctor, the physician, has not displaced and will not displace U.S. workers. This is important because if you recall, some of the things or the things that the government is trying to do since the new president took office is to protect American jobs, especially during this time where we have seen that there have been so many jobs lost. So they want to make sure that by giving all of these green cards to all of these healthcare workers, they are not going to be affecting the job market for U.S. citizens. The highlights of this, the Resilience Act, is that the per country cap do not apply. Green cards will be allocated based on the priority date. What that means, as you might know, the priority date is the date in which you filed the green card petition. So it's going to go in order of when the priority date was established. At the beginning, we said that the I-140 had to be filed before 90 days after determination. But if you look at the priority date, what we are seeing here is that probably they're going to have, or they will implement a system where people with older priority dates might have some sort of priority before granting visas to other individuals. Talking or attending some of the meetings with other attorneys and other government officials, it is, the understanding is that with these 15,000 visas that have been, or that will be allocated for physicians, it will be sufficient to cover all the backlog that exists currently for physicians in the green card pipeline. So that sounds good. Again, this is just a bill. It's in Senate. I always tell people, keep in mind that one thing is what we are seeing going into Congress, in this case is in the Senate, and a different thing might be what comes out, because it's going to be debated and they're going to talk and probably they'll make changes, and hopefully if it is approved, it's not going to change much of what is already there. Family members, spouses, and minor children. We know that minor children are children under 21, should be entitled and are going to be able to obtain green cards along with the main or the principal petitioner or the physician. And in the same order and consideration, meaning in the same priority date or the same category. One of the things they're saying is that these family members' visas will not count towards the 40,000. So it's going to be only the head of the principal application that is going to be counted towards those 40,000. Of course, since we're going to be giving green cards to more than one individual per family in many cases, then they will take and subtract those additional green cards from the overall numbers. Michelle and I were talking about this, and here is where we decided that this is kind of funny math, and until we see how they are going to make it work, we don't quite understand how they are going to be manipulating the numbers in a way that the entire family are going to be able to immigrate, and they will only count it as one visa. So we'll see how that works.
Creative math.
Yes, go ahead.
No, I just said that's some creative math.
Yes, which will work in our favor, so we'll take it.
Yes.
DHS, which is the Department of Homeland Security, is supposed to create a process to expedite, to premium process this type of petitions, or the petitions filed under this bill. So how is that? Well, they'll give priority to petitions filed under this bill as long as they meet the requirements of the bill. And this is broad enough that we believe that the expedite process is going to cover not just the I-140 that will be filed, but as well as the 485. So if they keep this language, what we will see is a process in which they will be processing these petitions on an expedited basis. And there's not going to be an additional fee to expedite the petition because it's going to be part of the legislation. So it's not like paying the $1,225 additionally for them to process it faster, but it's going to be in the bill. Therefore, people will not have to pay additional fees to get the petitions expedited. DHS will also expedite the shipping or mailing, sending the approved I-140 petitions to the Department of State. What that means is, remember, the Department of Homeland Security has oversight over everything that is immigration. USCIS, CBP, ICE, all of those. But then the Department of State, which is a different federal agency, oversees consulates, embassies, and all of those other offices. So if if the Department of Homeland Security, through the Department of Immigration or whatever other agencies they are going to expedite the process for I-140s and 485s to be approved, then once these petitions are approved, and if the individual is going to process the green card at one of the consulates, they always have to send these petitions to the Department of State or to the National Visa Center, whichever is the agency working with the Department of State to coordinate the interviews at the different consulates. So not only the Department of Homeland Security will have to have a means for the petitions to be processed faster, but also they'll have to come up with a system that will allow them to get the I-140, the approved I-140 quickly, faster to the Department of State so they can process through the consulates or the embassies the immigrant interview. So individuals can go to the consulate, get the visa, the immigrant visa, and come to the United States as legal permanent residents. Also, the Department of State, in addition, there's going to be so many expedite processes, but once the Department of State receives that approved petition, then they will also be required to expedite the process to get the I-140 processed by the interview by the consulates faster. Meaning, once the petition is filed, USCIS has to expedite it. Once it's approved, the Department of Homeland Security will send it to the Department of State for them to coordinate with the consulates and embassies, also on an expedited basis, the processing of the approved I-140, so individuals can get the interviews they have to go through to obtain the green cards. So if that is all done, and one of the things that is amazing with these bills is that, yes, Congress may approve it, and then we go into how is the Department of Immigration or the Department of State or the Department of how they are going to implement it is a different thing. Hopefully fast. That's for the Resilience Act. It's a short bill. It really doesn't have many pages, and it's specifically to address green card petitions for healthcare workers, nurses, and physicians, and to use or reuse the 40,000 visas that, according to them, are available because they accumulated since 2019, since 1992. So this specific piece of legislation is already in the Senate. There's a lot of groups advocating for this bill to go through. One thing that I've been recommending all physicians that I speak with is there is an association, PAHA, which is the Physicians Association for Healthcare Workers. They are very active and they have helped tremendously in advancing this type of legislation. So if you can get connected or affiliated with them, work with them because they are doing a great service to all the, international medical graduates.
So I'm going to be discussing the HEROES Act, which is another one of those that has gained a lot of attraction, and it's gaining traction. It's got a lot of very immigrant-friendly provisions in it. We very much support a lot of these provisions as well, but it's not as narrow as the Resilience Act, which is why we think that one is going to go through, but who knows. But so the HEROES Act it's a huge tome, and it talks a lot about many different areas. So we just pulled out the immigration portions of it, and one of the first things that we think is very generous about this, but it seems to be responsive, is extension on those filings and other deadlines. So if you were here and lawfully present on the U.S. as of January 26, 2020, you're going to be able, through this, get additional time to file your extension of status, change of status, apply for any sort of renewal of employment authorization, anything to keep you in lawful status. And then there is going to be a provision there for those who have expired I-94s. They're going to get an automatic extension, and that covers everyone. So think if you're a non-immigrant status, this bill would help cover any of those lapses that you might have, most likely, especially during this period of the pandemic as of January 26, 2020. The other thing that will apply to everyone under the sun would be the rollover of unused visas. So much like Angela was explaining how they came up with these 40,000 and kind of that was the number that's put into the resilience. They borrowed from that concept, this rollover of unused visas, but to make this into law to where it's a practice. Any unused visas will roll over into the next fiscal year as opposed to just poof, be gone. So, and that's what will apply to everybody. Now, obviously it's a HEROES Act, so the rest of the provisions that are really going to be focused on healthcare workers, doctors and nurses, and those are going to be tailored for them. So we'll go on to the next slide. I don't know, can I do that? Sorry.
Okay.
Angela, can you hit next? I can't. Thank you. All right. So, so you'll see under there, we're giving you the highlights, supplementing the COVID response workforce. So again, we're looking at these immigrant physicians and healthcare workers. So again, you'll see that applications or petitions for new employment or change of status, those will need to be processed within 30 days. That's one of the things that will be allowed to happen. In terms of medical licensure requirements, physicians know oftentimes that it takes a long time and takes a while. They're adding some flexibility there, which would be very helpful if, for example, you're working in one area and all of a sudden you're needed in another part of the country or another state, you'll be able to meet those licensure requirements. H-1Bs, this is important. They would not be required to file an amended petition or a new petition to be transferred to a new area of employment. Again, the practice of medicine needs to be related to COVID-19. So it's pretty precise. It's the practice of medicine, providing healthcare or engaging in medical research involving diagnosis, treatment, or prevention of COVID-19. And you'll see that phrase is duplicated in multiple places, again, to make sure that they're addressing this particular workforce. Now, there are additional provisions, and I know Angela's going to explain how J1s would be treated.
So for the J1s are those physicians who are here in that visa undergoing training, and it is well known that when you register for a specific training program in your DS 2019, it states what is the program and what is the duration. One of the things that this HEROES Act wants to address is what happens if at any time, and this is, it all goes to COVID-19, at some time during the training program, the physician has to be reassigned or redeployed, that's the word they use in the bill, to a new rotation within the host training institution, but that need the physician to go and work with COVID-19 patients. So what they are trying to do is that if this happens, and we know that currently the way the law is written, you cannot, or physicians in J1s can only work or work in related, anything that is related to their specific training. They couldn't go to a different rotation because it's not contemplated within their specific program. So with this bill, what they're saying is, well, if the need presents and the physician has to be reallocated or redeployed or reassigned to another program, another rotation, well, that they will still be in compliance. They will not be out of J1 status, and they can continue to work and help for as long as needed, and maybe go back to their initial programs or continue to work in that other program without having to change programs or refiling paperwork. So In that sense, this resilience or this HERO Act is very favorable for J1 waiver physicians who are undergoing training and that might be available to assist with COVID-19 work, but are not able to because their program restricts them from helping out.
Yes, and then for O1 physicians, if they're seeking extension of status, they're going to be authorized to utilize what we have traditionally called the H1 portability provisions. They will be able to exercise those provisions as well under this bill if it passes, which will open up some opportunities for them. They can accept new employment, and that's a change for the O1 physician that I know would be very welcome.
For those of you who are not familiar with portability, what that means is, for example, which is how it works right now. If you already have an H-1B visa and you change employers, then you can start working with the new employer as soon as the new H-1B visa petition is filed. You don't have to wait for the approval of that H-1B, the new H-1B visa petition, to start working with the employer. That's what portability means. Well, with the O1 visas, there is no such things right now. So if you want to change employers, then yes, you have to file a new petition, an O1 petition, but then you couldn't start working with the new employer until that new O1 petition is approved. That's how it is now. They want to eliminate that to make it similar to how it works with H-1B visa holders. We also see in this HEROES Act, the Conrad 30 program, and there is no way they talk about international medical graduates without talking the Conrad 30 program. As many of you know, the 30 Conrad, State 30 Conrad program is a federal program that allows every state or each state to grant at least 30 waiver slots to physicians every year, to J1 physicians. The basic waiver is if you are in a J1 visa, you are required to go back home or the last place of residence for 2 additional years or for 2 years before you can get a green card or get an H-1B visa or you wouldn't be able to stay in the United States. So the J1 waiver, what it does is allows physicians to stay in the United States because it waives those 2 years as long as they commit to working in an underserved area for 3 years. So what this bill will propose is to increase the number of visas, because right now states only have 30. They only have 30 slots. They are looking to increase it to 35. And that the numbers of the waivers can be revised from year to year, and that the states or the federal government might adjust the number of waivers that might be available from year to year depending on the demand and the previous year.
Okay, one of the other provisions included there is employment authorization. Employment authorization is important because an EAD card, employment authorization document, is what anyone needs to present to show that they are employment authorized and not necessarily tied to one particular employer. For example, H, you're tied to your employer. O, again, you're tied to your employer. So it provides for independent temporary work authorization valid for up to 1 year. And the physician would, or healthcare worker, is given that mobility. Again, it's for flexibility to engage in COVID-19 work. So how would that be documented? Obviously, we get to know that. But this brings to mind something that we've been doing for a lot of our physicians that are backlogged, that are stuck because their priority date's not current. And they are frontline workers. They're working as hospitalists. They're in the emergency room. It's an EAD that is valid under law. So not looking at this bill, what we do have available to now is an employment authorization card under the category C35. It's under compelling circumstances. there are certain requirements that have to be met. So I'll just go over them briefly. But if you're in E3, H-1B, O-1, or L-1 status, and you have an approved I-140, so you have an approved I-140, but your priority date is just not current. And here's the tricky part. You can demonstrate that compelling circumstances exist that would justify USCIS using their discretion to give you this independent employment. Well, for our physician or frontline workers, we said, yes, they're needed in the ER rooms to handle COVID. And we've been getting those through. So, but here's the tricky part. And I think, Angela, you brought this to my attention. Once a physician uses an EAD under the C35 category that exists, they're not maintaining lawful status. So, and that goes into the next point. Right now, if you were to use that, you are not maintaining lawful status. So we would have to seek a way to get you reinstated in your H or O status.
Well, let me make a clarification, because I don't necessarily agree that they're not maintaining lawful status. They continue to be lawfully in the United States. So the lawful status doesn't lapse. What lapse is the non-immigrant status.
Yes.
So what they're saying is, yes, great, we'll give you the EAD based on compelling circumstances, the C35 category. But once you start using it, sorry, but you're not going to be in H-1B status and EAD at the same time, similar to what they're doing with H-4s and EADs, which is fine, because they will still have a status, well, not a status, but they will still be legally in the United States and working. But once the time comes for them to file or for you guys to file the 485, then we have to put you back on H-1B, or you have to go out and come back with H-1B to be able to file that 485, because the 485 requires an individual to be in non-immigrant status to be able to file the 485. So that's the tricky part. We have been managing that just fine. And it's not difficult to do the reinstatement or to go out and come back with the H-1B. It's just time consuming. But as long as individuals, and we have been doing it, as Michelle said, have clear what the requirements are and where we are, there should not be any problems. And what they are doing is approving those petitions because they need physicians to help with COVID-19 work. So it's doable, but that's kind of, many physicians don't want to do it because of that little caveat. One of the things we always tell physicians is do not leave your H-1B employer, because that EAD doesn't give you anything but just an authorization to work. And at the end of the day, you might still need that H-1B employer if you have a labor certification, or you need to demonstrate or prove that you have a place to work.
Exactly. Thank you. But that's also why this bill, if it passes, the next point, the maintenance of status issue, it does away with that, just like Angela's explained. So the concerns that we have presently with these sort of situations under that compelling circumstances EAD is done away with if this goes through, because right there you get the EAD and there is no disruption in the underlying non-immigrant status. So thanks for the clarification.
Correct.
And okay, and so
the treatment is of time spent engaging in COVID-19 related work. I'm sorry. So as you know, and this mainly refers to the National Interest Waiver 5 years compliance and the J1 waiver 3 years obligation. So what they're saying is, if this bill goes through, if a physician at some point during the 5 years of the NIW requirement, or during the 3 years of the J1 waiver obligation, remember, once you get the waiver, you have to work in the underserved area with the specific employer for 3 years. So what they're saying is, if at some point, for example, you are working with COVID-19 patients or related work in an area that maybe is not underserved for whatever reason. I mean, there are many hospitals and healthcare centers that are not in underserved areas. They still need the help, and there is still seeing COVID-19 patients. So if physicians, for whatever reason, need or have to go and work in these areas that might not be underserved areas, they will still give them credit for the 3 years or the 5 years that they are required to work in underserved areas in compliance with the national interest waiver or the J1 waiver requirements, which is great because many times, again, we go back to the need of physicians to help with the COVID-19 population. And when physicians are tied to these 3 and 5 years obligations, they don't have the mobility. They can't just pick up and go because then they will be interrupting the 3 years or the 5 years, which is going to work against them. So it would be the fair thing to do, I guess.
And then perhaps one of my favorite provisions of this bill is a special immigrant status for non-immigrant COVID-19 workers and their families. So basically, if you're a frontline worker and you are a COVID-19 worker and you are maintaining your lawful non-immigrant status, you will have a way to become an immigrant, which means green card. So the special immigrant status is going to provide a way for that green card path. It's opening a green card path. We have special immigrant status in other areas of the law. So this one would be particularly welcome. But again, got to keep sure that we're looking at the narrow scope of it. And then let's see. Okay, and then there's protection for surviving spouses and children. Now, just much like the EAD situation, there is something that we have that currently is in place. But under this bill, the surviving spouse of someone who passed away as a result of providing medical care related to COVID-19, again, that just alerts us that it will have to be documented. The family may be granted the immigrant visa or adjustment status, so they could come in through the consulate or here while the application is pending and maintain lawful non-immigrant status. So it's a provision. Now, there is a surviving spouse provision that exists. It's in the law, but that one has more requirements. It's very much discretionary. It's not written in a way that is very automatic as this provision. So the requirements that you have to meet under the current surviving spouse provision or law is not nearly, that's very stringent compared to what they would allow for in this situation.
Yeah. Yes, and I think this provision is more than fair. I think it's just. We have been talking with many physicians, that their main concern is precisely that. I'm working with COVID-19 patients, so my life is at risk every day that I'm out there. And in the meantime, my family is home. My spouse is a stay-at-home spouse taking care of the family. And if something happens to me, and not only I'm exposing them as well because I go home every day, but if anything happens to me, they have to leave. Yeah. And they have also been living in this country or doing as much as I had been doing for all these years, and then they'll have no protection if I have to leave now, even if I have an I-140 approved, which there are some provisions out there, but they are coupled with other things. But it's accurate. This will be very straightforward protection once you have these conditions. And it's not just any physician. And we really don't know how that will be implemented. Remember, all of this is geared towards COVID-19. So if it is a physician who does work unrelated to COVID-19, well, maybe those physicians will not benefit from this type of legislation. But I think that at the end of the day, one way or the other, pretty much every physician is going to be involved with COVID-19, whether because they come into contact with somebody for the first time or something else. But it is at the end of the day, it will be how these provisions are implemented. With this bill, and we're going to open for questions, but one thing I wanted to say about this bill is that I was reading and researching for this presentation, and I found out that the government, the White House, made an announcement last week that this bill in the form that it is written, they would not support this bill, and the president might veto it. And it can pass the House of Representatives, it may pass the Senate, but the president still has to sign it. And one of the reasons is that for what we show you here is only the provision for this specific bill, for this the HEROES Act. We only show you the part related to immigration, and only the related to employment-based physicians immigration, because there are other things for deportations or removals or people under custody, and we're not going to talk about those. But the bill is extensive. It has a little bit over 50 pages, and most of the bill is about the CARE Act, the budget, the money that is going to be allocated to benefit employers, companies, employees, programs that might be created or that have been created to use the money that was appropriated for the COVID-19 emergency. We're talking a couple $2 billion. So as you can imagine, this is not going to be a simple debate in the Senate, and you might find a lot of senators that are not going to be so amicable in terms of passing this bill. I think that we might have better chances with the Resilience Act, which is very simple, straightforward, and they are just trying to use unused immigrant visas. And that's the bottom line. We just want to use these ones, and these are the requirements. Let's get this done. There's a lot of support for that one. We are still waiting to see how this other one, the HEROES one, is going to evolve. That being said, please keep typing your questions. We already have a couple questions here. So I'm going to read the first one. And it says, if you want to say something, if you would like to ask your question live, please raise your hand and we'll give you the microphone. The first question is, do you think this bill is going to help certain nationalities like Indians, Chinese more than others? Or do you think that is going to make waiting time longer for nationalities like Jordanians or Iranians? Michelle, do you want to answer that one?
Well, okay, so it depends. First of all, Jordanians and Iranians are under the worldwide category, so already their priority dates are always leaps and bounds ahead of our Indian nationals and our Chinese nationals. So right then and there, the system already puts worldwide category ahead because of the way the numbers are allocated. So a lot of these bills, at least for the HEROES Act, it's going to streamline it for those physicians. And that's where they're not looking at priority date. They're going to take you out of line of priority date. So especially those that have been waiting for so long, I personally feel like it's just right. They've been here on a backlog for years already, serving as physicians. I feel like it would only be just.
Yeah. Well, and the other thing is that we're talking about two different bills, and the question here was this bill. So I imagine, or based on the time this question was written, I think you're referring to the Resilience Act. If you saw in the presentation, one thing that the bill mentioned is the priority dates. So they are going to keep in mind priority dates, and definitely, like Michelle just said, Jordanians and individuals from Iran, they don't have priority date issues to this moment. Okay, we can't predict how the future is going to be, but traditionally, they can file for the green cards, meaning the 485s, or go to the consular post as soon as they are able. Okay. For people from China and India, definitely that they have priority date issues. I think those are going to be the ones that will probably benefit the most with this bill, because the 40,000 for physicians, 15,000 unused visas, they are going to be allocated according to priority dates. So for those, well, that's what they say here in the bill, not the different thing is the implementation. But so it kind of makes sense that those who already have a priority day, and the older the priority day, the bigger the chances that they're going to be able to get a green card based on this Resilience Act. Hope that answered your question. If not, please send us an email and we'll be happy to continue the conversation. There's another question here. How about physicians who are on H4 EAD? Well, right there, we're talking about H4s are dependents of H1Bs. And as we noted, if a physician principal, the main physician who has the H1B qualifies to apply for the green card based on either one of these bills, then the spouses and children will be able to follow them, meaning they'll also be able to apply for green cards based on the category or the qualifications of the H1B spouse. So for H4s, EADs, they will benefit as well as the H1B physician. Now, if the question is what is going on with the H4 EADs, we gotta say the same thing we have been saying for a couple of years now. The administration says that they intend to do away with the H4 EAD program. It has not happened, so we continue to file them. They continue to approve them. So as far as we're concerned, it is alive and with no issues at this point. Anything that you'd like to add on that one, Michelle?
No, just the H4 EAD, that's half the battle. You have the EAD, so you can go work so long as the H1B principals still doing what they're supposed to be doing.
Yeah, and you keep your H4 status, so
yeah,
I think it's a win-win situation there. The other one is, there's another question here about the C35 EAD. Can I change the status to H1B after EAD expires in a year? Do I have to leave US in order to change the status to H1B? It depends. Like we mentioned, we could ask for reinstatement of status as long as your H1B visa is valid. Okay, so for example, you start using your EAD based on the C35 or compelling circumstances, and in a year, your H1B approval notice is still valid and valid for at least a few more months or 1 more year or maybe 2 more years. Well, you can ask for reinstatement because your visa is still valid. And then you just have to wait for the Department of Immigration to work out the reinstatement and put you back on H1B. Or if you don't want to wait, the time that the USCIS takes to do the reinstatement, instead, in the event you are not able to ask the Department of Immigration to premium process the reinstatement, then you could travel outside the United States and come back using that H1B visa. Again, you have to maintain employment with that H1B employer to be able to come back that visa to enter the United States in H1B status. If you don't have an H1B visa stamp on your passport, you can still leave, go to the consulate, apply for the H1 visa, and come back in H1B status. So yes, it depends on what's going on with you at that point. You might be able to apply for reinstatement, or you might need to leave and come back and reactivate your H1B status.
I did want to add, and Angela, I don't think I mentioned it, but we should let everyone know, we have been seeing great success with expedited processing for COVID-related filings. So for example, the C35 EAD, we've been able to utilize, because premium processing is out and it doesn't apply in these particular cases, we've been able to send letters explaining the urgency of COVID-19 related urgency of getting this EAD issued and approved, and CIS has been responsive. So that's something I think you should know.
Yes. I have a couple other questions here. One of them is, do you have any idea when S3599 can pass the Senate. And thank you a lot for sparing time to do this. Well, you're welcome. We enjoy having these forums, so to give information as much as possible. We don't have any idea. Quite frankly, there are some speculations out there, and I have heard attorneys saying something about maybe in a couple weeks, or maybe before the end of June, or maybe, remember, Congress goes on vacation, and quite frankly, I lost track of that. So I'm not sure when they are going. And do you know, Michelle, when they will be on vacation for the mid-year?
No, I don't. But
so depending on that, and depending on how much pressure or how much people are advocating for this, they will be moving the bill along. It has moved quite, in my view, it has moved fast, because it was introduced, the HR 6788 was introduced in Congress in April, mid-April or so, and it was then passed by Congress, I mean the House of Representatives, and then it went to the Senate. It was passed rather fast, and it went to the Senate, introduced on May 5th. So it has been in the Senate since the beginning of May. How soon? Hopefully soon.
Hopefully by the summer.
Yeah.
Here's the thing, anything that's COVID related, we are seeing is moving quickly. There's a lot of attention on it. There's a lot of spotlight on it. It definitely moves a lot quicker than we've seen other legislation move through, but we're still not there yet.
The other thing that we need to keep in mind is, remember, fiscal year. Always keep in mind fiscal year. The new fiscal year starts on October 1st. So if they really want to reuse all of these, not that they couldn't do it after October 1st, because that's the whole thing, to recapture all of that. But I'm thinking they don't want to start the new fiscal year not knowing what is going to happen with these 40,000 and some visas that are available, because I'm pretty sure that between now and October 1st, the 40,000 visas are going to go up. We might have a few more visas, because we're still allocating green card visas at this time. We still have 3 more months, June, July, August, and September, 4 more months of this fiscal year. So instead of talking 40,000, we might be talking 45,000 in 4 more months. So at some point, they need to be doing something to be able to work with the numbers that they currently have. So hopefully soon, we'll try to keep you posted. And as we hear things, we'll continue to send our newsletters, our immigration alerts, and certainly doing more webinars to keep you posted.
Definitely want to plug for you guys to subscribe to our newsletter, because we are keeping you informed.
Yes. I'm a Covey, I'm a Covey frontier, and working since 10 years, desperately wanting for the bill update. My priority today is 2011. I wonder if I will be qualified. Well, definitely, I think that you meet the perfect profile that this bill is targeting. So if the bill, the Resilient Act is passed as it is, I think that you will very well qualify to file and get your green card this year, hopefully this year.
That's to schedule your consultation. We'd love to help.
Yes. Is there a time frame for which Judiciary Committee, which is the committee in the Senate that is reviewing the Resilient Act, should give a decision, everything going smooth and average? I think we already answered that question in the question before, that there's a lot of things happening. I know there's a lot of people in trying to get the different senators. So if you have a chance to participate, again, PAHA is doing a great job. Get in touch with them. I will post the contact information so you guys can help to advocate. If you know senators, go talk to your senators. If you have employers who have relationships, go talk to the employers. The more people that contact senators at this point about this bill, the better chances we have, because they do listen. and it's about the numbers at the end of the day. I have a question here about is there a time frame by which judiciary can, we talked about that one. Do we have an estimate how many physicians are there in backlog? Will these 15,000 visas cover some with priority dates of 2019? The latest, every time, I belong to a couple of us, or we belong to a couple of associations of physicians, attorneys, and also physicians that work with physicians. And even talking to the Department of State, Charlie, and I forgot his last name, I'm sorry about it. The guru of, I'm sorry?
Charlie Oppenheimer.
That one, exactly. He's the one who knows the numbers, and he's constantly giving updates as to where we are and how many visas we have available and what is the backlog and how the dates move every month. Every time we talk to some of them or somebody comes up, the numbers change. When we started to talk about this Resilient Act, the number was about 12,000 physicians in the backlog. And then the number went up to 15,000. So, and I think that that was part of the information that the drafters of the bill used when they decided how to allocate the visas, 25,000 to nurses and 15,000 to physicians. Sounds capricious, but I think that they got that information from somewhere. So they believe that with this 15,000, it is very likely that they will take care of the backlog, and probably someone with a priority date of April 2019 might be able to get one of the visas. I think that at the end of the day is how this is implemented that is going to make the difference. Couple other questions, and I think we're almost on time. So let me go through this question, and then any other questions that we're not able to answer, we'll send you an email. My husband, that is a non-physician from India, has a priority date somewhere in 2018. If I, a physician, join his priority date, will that help to sooner green card? Priority dates are not transferable. So if your husband is the one who has the I-140 petition and has established the priority date, and you do not have an I-140 petition and you do not have your own priority date, this bill probably will not cover you unless you hurry up and file an I-140 as soon as you can. Right. So my advice is call us. We can talk to you about what are your options depending on your specific circumstances to file an I-140 as soon as possible, and maybe you will be able to get into the pool of the visas that might be granted under the Resilient Act. But
right, and then and under the HEROES Act, if you're maintaining your non-immigrant status, which sounds like you are, obviously, then if you would qualify for that special immigrant status that they'd be creating too. So there is something that we could probably do there to help you, to position you for that, if it passes.
Yes. So you'll need your own. You couldn't just tag along with your husband and expect that because you're a physician, they're going to change. That part of the law is not going to change as far as we can see.
Right.
Will these 15,000 visas be distributed solidly on the priority days or also stratified by employment categories? We're talking physicians. We're talking I-140s. Physicians necessarily are either in EB1, EB2, or EB1. EB1s usually don't have priority date issues. It's mainly EB2s, but they're talking about priority dates. So yes, that's something they're going to be looking at. Okay, cross chargeability, last one, and this is the last one. I'm sorry. We want to respect your time. Cross chargeability. The law is the law. Still applies. If you can claim your spouse citizenship for purposes of processing your green card, do it, because you don't want to be stuck in the backlog if you're able to use your spouse nationality. Okay, so I think we're done for now. We apologize if we're not able to answer your questions. Thank you for taking the time. Again, please feel free to contact us, and we're happy to help. And call us or let us know if you have other questions. We'll keep you updated. We'll let you know any changes. And thank you for taking the time. Until next time, right?
Bye. Thank you.